Hi everyone, just doing a little sound check to see if you can hear me okay. If you're already watching us in live, please put like a little plus sign in the comments that we can see that you can hear me okay. And I will be starting in just a moment with my presentation. So the presentation is loading, yeah, and I hope you can see everything nice and clear. Excellent. So today we're going to talk about trademarks, how to protect your trademark. It's mainly focusing on the European Union, but this presentation will be equally useful for those who are considering registering a trademark abroad, whether it's United States or outside of the European Union area. I will be talking about various funding opportunities that are currently available, and we'll be covering things what to do, what not to do. So today you will learn what is a trademark. For those of you who is new to this subject, we'll answer the questions why it is important to register a trademark, what exactly to register and where, in which countries and what jurisdiction, how to decide where to register a trademark. We'll be talking about differences of trademark sign and register sign. I will be talking about some of the mistakes that you should be avoiding when registering a trademark. And for those of you who will stay with us until the very end, we'll cover the very main subject of today's presentation, how you can actually avail of 75 grants from the European Union on your trademark fees. And there will be also a bonus to all the attendees. So without further ado, just a little bit of housekeeping. There will be a recording available in case you are joining late or you get disconnected or you need to leave earlier or you can't attend. We recommend you to switch off your phones, and if you are actually viewing the stream online, that you actually switch to computer on a larger screen so you can see slides better. Now, ask questions in the chat. We'll have a Q&A session at the end. If there is any questions, we'll answer them towards the end. So let's get to know each other. My name is Alex Chernenko. I am the CEO and founder of Chern & Co. Myself, I'm an entrepreneur with over 13 years of experience. I normally attend different webinars, conferences, act as a speaker and as a business consultant. We help entrepreneurs to succeed by taking care of all the paperwork, accountancy, and matters that would be associated with a running day-to-day business. Now, myself, I have a different brand that I have owned in the past years, that I have bought or sold. I believe that every business should register trademark, again, for protection and for other reasons that we're going to discuss today. But I've been registering my own brands in European Union, in Ireland, that's where I'm located, United States, and a couple of other jurisdictions. Now, to tell you a little bit about what we do as a business, Chern & Co was founded in 2009, and our main area would be company registrations, informations, trademark registrations in 4 jurisdictions: European Union, United States, United Kingdom, and Ireland, where we are located. We handle everything from VAT registration, tax filing, tax compliance point of view for businesses that are setting up in these countries. We also act as a European representative and responsible person for those businesses who wish to enter European market but don't want to set up a company. And we do it for over 13 years. So let's go to the main subject of today. What is a trademark and the definition of the trademark? There are many definitions that you can find, but this one is the one I like the most. So trademarking is the only way to legally protect your ownership of your brand. So if you think about it, you could register a domain, you could register a business name, but that doesn't give you a protection. If you actually hold in a registration certificate, that is a protection. And it's actually a legal way that someone already recognized. For example, take Ireland. If you register a company, companies have a unique name, okay? But if somebody else is trying to open a similar company, they can still do it with a permission. And if you're talking about business name, there is completely no restrictions. So, 10, 20 people could set up the same business name without any restrictions. With trademark, that is not possible. So it's the best way of protecting ownership of a brand in a way. When somebody needs a trademark, and why it's important, why it's important to actually trademark. And I listed out here main 3 reasons that I'm gonna cover. Others cannot challenge your brand. So if you already have a registered brand, that means that it's been recognized legally, and anybody else would have to essentially overrun that recognition. So the only way for somebody to challenge your brand is to go to an expensive court proceeding and trying the court to issue an order to overrule yours. So it's actually very difficult for somebody to challenge a brand that's already registered. That's why trademark is so important. Now, if you have a trademark registered, you can stop others from using your brand, and you can do it by writing them a letter of demand or cease and desist letter, or you could actually contact the relevant authorities. But if you are holding a certificate, it's very easy to stop someone else from selling because you essentially are the brand owner. If you look at trademark from a third reason, and obviously one of the main ones, trademark is actually an asset. It's actually something you could sell, or you could lease, or you could rent. If you look at the most important brands, why they're so valuable, why the big brands actually have such high capitalization. It's not just because they have essentially large amounts of money sitting in their bank account or because they're large sales. It's also because their brand is recognized. So if you are growing your own business to a certain point of growth in its, let's say, business journey, brand becomes so recognizable that it actually has a perceived value. Even your company, for example, doesn't generate a lot of sales, your company doesn't sell a lot of products, but your brand is recognizable and well known, you could still sell it just on that perception of the brand. So trademark is actually something that you could sell, and that's what some celebrities are doing. They have a personal brand that can be also trademarked. In terms of other benefits, such as brand recognition, brand protection against copying that we already mentioned, trademark also allows to prevent importation. In the United States, it is possible to contact the border customs and essentially notify them and infringe the counterfeit goods. So the goods that are being imported, for example, in the United States for a trademark registered owners could be prevented just at the point of border control. And that's something that only registered trademarks can do. Brands that have recognized names that have certain visibility and registered trademarks, it also makes it possible to hire and attract talent. Obviously, people would like to work for brands that have some sort of reputation and credibility rather than unknown brands. So it also gives you a chance to attract better talent. And for those who are actually selling on e-commerce websites such as Amazon, eBay, or other marketplaces, most of those e-commerce platforms have a specific program for brand owners who have registered trademark. In Amazon, for example, it's called Brand Registry. In eBay, it's called VRO, or Verified Rights Owner. So what those programs are doing is giving additional flexibility, additional content marketing tools, and additional protection for the registered trademark holders to be selling on those websites. So you get more exposure, more visibility, and you get more protection within the marketplace itself, allowing you to stop others from selling similar or identical products to yourself, which is only possible, again, to the trademark owners. Another benefit that we see with individuals and businesses as well is passive income. So when you look at it, if you have a brand that already making money, you could actually give a permission to use your brand to somebody else. And it could be done in a form of franchise, it could be done in other contractual obligations or agreements, but essentially one person gives permission to another person, whether it's company or individual, to use their trademark on their products, in their promotional materials, and receiving a passive income for that. That's a way to essentially, once you've grown your business to a certain level, you could license it to somebody else and it will still be making you money. So that's the reason why you also should consider registering a trademark. What to trademark? That's a very common question, and probably the main and the first most popular item is of course business name. So if you have a company name or a business name, you would like to register it that nobody else can have it. The second most used probably is the logo. So if you have essentially an image that represents your brand, you would be equally interested to register it. Third, by the popularity, goes as product or service. If you come up with a unique name for what you're actually doing or selling, that is also a candidate to be registered. And last but not the least is slogan. So if you look at different examples like Nike, just do it, that is a registered trademark. So essentially slogan or phrase can also be trademarked that nobody else can use it. Another question that we get often asked, where to register trademark? And you would obviously start where you are located in your country. So if you are a tax resident, you are living in this country and you have a trademark, you obviously would be doing it where at the point of your address, whether it's individual or business. Now, if you are based in one country, but you are selling your products in another country, for example, you're based outside of European Union, but you decide to sell on, let's say, Amazon Germany or enter European markets, you would be registering a trademark either in a particular country or in the whole European Union, because this is where you get a protection. So you would register it where you make sales or where you run your business. And last point, country of manufacture. Very simple example, but this example is not often discussed by other trademark agents, that you should be registering trademark in the country of manufacture. You, for example, you are producing goods in China and you're importing them into European Union. If somebody registers your trademark in China, that it could actually stop you from exporting goods from China into Europe. So you have European trademark, but you don't have a Chinese trademark. If somebody actually gets that name, they could enforce a restriction on the exportation of your goods. And this is something that sometimes people don't think that trademark in country of manufacture is important. It actually is. And some of the Chinese sellers could actually utilize this loophole. Now, when you should be registering a trademark if you intend to use it, we recommend between 6 and ideally even 1 year before you need your trademark. So if you are launching, for example, a new business and you get all your branding right or your marketing campaign, you don't want to be starting and then applying for trademark, because it could be delayed by as little as 5 or 6 months in the European Union, or 9 and even 12 months in the United States before you receive the official certificate of registration. So ideally, you would be planning 6 to 12 months application prior to when you actually would like to have it started as sooner as possible. Very common question that I'm being asked often is, what's the difference between trademark symbol and registered symbol? And it is a very simple explanation. Trademark means that somebody wants to claim ownership of a brand, but it doesn't mean that it's actually registered. So anybody could come up with a name and stick TM label on it. But the registered symbol actually means that trademark is already registered. So it's essentially proof of trademark registration. So all the big brands, they obviously use R, which is registered. It means nobody else can use that brand. TM is just an intention. It's not a guarantee of registration. Customers frequently cannot decide at the beginning whether to register a name or a logo or both. And sometimes, people would go for a name, sometimes people would go for logo. So how to make that decision? And you could use the following answer, that if there is a chance of similarities, registering a logo would give a better chance, because similarities between graphics is less than similarities with the name. So if there is essentially a risk of similar trademark, then registering a logo would slightly increase the chances of registration. So sometimes businesses register logo first, and then after receiving the registration, go in for the name. That way you are covering both name and logo. If there is a chance that your logo will be changing in the future, then register brand name would be better, because you could then use it with different graphics element. And that should be your essentially reasoning when making a decision. Quite often, businesses also think, shall I use a black and white version if I'm registering a logo, or shall I use the color? Is there any difference? Am I protected or not protected? And the answer would be that it's treated different in different jurisdictions. In the United States, using color versus black and white is more relaxed. So generally, trademarks that would have color variations would be somewhat safe to be using. In the European Union, they're a little bit more strict, and there has been a clarification since April 2014 that color and black and white trademark are not equally the same, and therefore should be registered differently if you intend to use both versions. Should you register trademark as an individual, or should you register it as a company? And you can use this as a guideline again to help you make the decision, and I'll just run through the comparison. So talking about confidentiality, if you are going as individual, all details of trademark owner, including home address, email, phone number, will be available publicly. That means no privacy. On the other side, if you are registered as a company trademark owner, details of the company, they are already in the public domain, and it ensures some level of privacy for individuals. So there is no need to put your mobile, your essentially home address, and obviously your email address. It's going to be public company details that are already available on your company website. In terms of intellectual property rights and rights of ownership, generally with companies it's cleaner and easier to manage, because ownership of the trademark remains with the company. Even if something happens to one or the other director or shareholder, the trademark ownership remains with the company. Contrary, for individuals, the owners remain with individual, and if it happens that the individual passes away, then the IP rights will be similar to property, and the right will go through inheritance process where the next of kin will be identified, and then they would essentially consequently become an owner. Therefore, moving rights from individual to individual a little bit more complex than doing it with a company. With company, there is better controls. Now, in terms of liability, normally if the incorrect use of trademark, or there will be a trademark infringement due to individual actions, that personal liability would be 100% on the individual, including their personal property. So if there will be a court case or a certain claim, penalties and fines could be imposed on that individual, essentially collecting that assets from their possession. On the other side, companies generally have limited liability, and it's treated separately to the individuals. So if there will be company court case in relation to trademark, or there will be certain claim, usually that responsibility would fall on the company, and company could just be closed or liquidated, but the personal assets of the individuals, shareholders, are generally safe. That's another reason why it may be better to put it through the business rather than individuals. And last but not the least point is, of course, taxes. Passive income on individuals is generally taxed higher, and in some countries it could reach easily 33%. With companies, there is more control and flexibility how to divert taxes through the dividends, through, again, capital gains tax, and there are other variations how companies could actually save up on taxes, which is limited to individuals. This is a very comprehensive slide, but I will be going through most common mistakes that actually could result in refusal of trademark. And we're going to go through them one by one. So not doing a search or doing a poor search is the number one reason for refusal. There are many resources that you could use to search for similarities, or you could delegate this task to a trademark professional who could give you the percentage of success of running your trademark. Not using trademark anywhere, that means that you come up with a brand, but you haven't publicly used that mark, so you don't have actually a proof that your trademark has been used. You're keeping it as a secret. That is not recommended. With trademarks, you actually need to have a proof of using your trademark in commerce. With patents, yes, it's completely different. With patents, you would not use your technology in public, and you would only go through the application, and after application is granted, you would actually publish it. With trademarks, it's the other way around. You need to be showing evidence that your trademark was used in commerce. Reason number 3, not having business name or local registration. So you come up with a brand name, but you haven't registered anywhere on the local level. That is not recommended. One of the first steps is actually getting a local registration, have some sort of document with your local registrar of companies or other business registry authority, and after that applying for the nationwide trademark. That is a recommended process that will give you an extra level of protection. Mistake number 4, brand name is descriptive and there is no uniqueness. Unfortunately, you cannot register trademarks that just explain what your product or service are doing. Your brand name needs to be unique, and it's very hard to register just plain words that are descriptive. We also see many refusals if people try to register their personal names or surnames in trademarks. That is very hard to register unless your business has been using a long-established family name for a number of years. Then you shouldn't be applying for using names in the trademark. Reason number 6, using someone else's brand, registered, unregistered. So if you notice that there is a really good brand in one country and you decide, oh, I'm going to use it in my country or somewhere else and I'm going to try to register it, that's essentially a recipe for disaster. You should not be trying to register brands even that they're not registered in your jurisdiction. It's a risky area. You could be then liable for any profits or gains that you have accumulated as the result. So, come up with a unique name. Don't try to copy anyone else where their brand is registered or unregistered in particular country. Reason number 7, not actually registering trademark. So if you have a very well established business and you come up with a brand name and you are selling it and you're not registered, that increases risk that somebody else would actually try to copy it and stop you from selling this. And next slide actually will be given an example of number 7. So just bear with me. We have a few more reasons to go. Number 8, using trademark on product services not listed on registration certificate. So sometimes you would register trademark and you have 1, 2, or 3 products that you intend to use it. Now, after a couple of years, you decide to launch a new product and you just stick your label to it in completely different category. You officially are not protected. So if you are trying to use the brand with the product that is not listed on the registration certificate, you're not protected. And actually, patent offices worldwide allow registration of exactly the same brand names, but in different categories of products or services. So automatically, you cannot modify the number of categories or types of product. You actually need to register a new trademark. So if you intend to add new product, just apply for a new trademark with that particular product category or type. Going to number 9, using variations of trademark. So that means you registered a trademark, but then you decided to add another word like pro. So if you come up with a name and then you have a variation that adds another word, that means that that new variation is not protected, or you slightly modify your logo that you have registered. Again, you will not be 100% protected. That's why using variations is not recommended. You actually are recommended to register variations as a separate trademark if you want to be protected 100%. Reason number 10, registering trademark in someone else's name. So think of it this way, that you registered trademark, but you didn't want to become the owner. You registered in one of your relatives or even friends. Then changing the ownership or doing anything with that brand becomes difficult because you don't know what's going to happen to your relationship with that individual. Therefore, registering in someone else's name and then trying to claim ownership would be very difficult without consent of the person, of course. Reason 11, forgetting to update contact details associated with trademark. We actually had one of the clients who received an official correspondence from the patent office, and that correspondence went to an old email and an old address that that person is no longer available at, and that person hasn't responded. As the result, they lost actually rights to their trademark. So this could happen to anybody. Therefore, making sure that up-to-date contact details are saved in the official patent office is critical, because you could be receiving very important communication that you need to be dealing with in a timely manner. So if every couple of years, just check up and ensure the details are correct. Last 2 reasons: spelling mistakes, not following application guidelines. Again, sometimes people decide to apply for trademark themselves, and it's very easy to do a mistake when it comes to the filling in the application form or not following the application guidelines that a trademark expert would usually know about. So any spelling mistakes, any mistakes within the application, not following the process is one of the top reasons for refusals. And finally, again, trying to do things yourself without professional help basically decreases your chance of registering from the very first attempt. This is an example I've been talking about. It's a very recent news. This has been discussed in the last 10 days. So essentially what happened, Kanye West, which is a black American rapper, started selling shorts with White Lives Matter written on them. Another individual essentially applied for this phrase to be trademarked and assigned the trademark ownership to the two black men that are actually they have their own radio podcast. So one individual wanted to stop Kanye West from selling shorts with this phrase, White Lives Matter, as the result of, we're not going to get into any political conversations, but, bottom line story that Kanye West has been selling shorts. He hasn't registered that trademark. Somebody else registered trademark, even dropping the point of assigning it to somebody else or not assigning. But now these two individuals that you can see on the photo, they essentially stopped anybody from selling shorts or t-shirts with White Lives Matter on them. What were their political reasons? It doesn't matter. It's not the point of our discussion today. But the lesson learned, Kanye West should have registered a trademark before he started selling those t-shirts. And he didn't. As the result, he lost now the right to this phrase and he can no longer use it. That's it. And he may be even able to pay some penalties if he sold any goods after the trademark was registered. Now, moving on into the European Union, just a couple of points for you to consider before registering trademark, just to give you a little bit of additional information. That official authority is European Office Intellectual Property, European Union Intellectual Property Office. The fee to register one class is normally €850, and then you pay for each additional class €50 up to 3, and then the price increases if you really want to add a lot of classes, more than 3. It used to take from 3.5 to 6 months. Now we see more on the longer time scale. So it actually takes on average 5-6 months at the moment. With the level of applications that the patent office receives, it just takes longer than before. It's valid for 10 years and you must have a European address. If you're registered trademark in the European Union and you don't have address, you need to have essentially a European representative. That's usually a trademark attorney. And we can assist you with that if needed. So coming towards the end of my presentation, I want to talk about grants that are currently available with the European Union Intellectual Property Office. It's called SME Fund. So it's a special funding by the European Union to help individuals that are based in European Union and companies that are based in European Union to actually protect their brands. This grant is not available for individuals or companies outside of European Union. So you need to be either a tax resident or you need to have a company somewhere within the Europe in order to avail of this funding. So what's the funding about? It's given in the form of 2 vouchers. One voucher kind of covers trademarks, intellectual property, scan or test, and the second voucher is for patents. We are focusing on the trademarks today, so I'm going to be talking about it in more details. So on the trademarks, you are allocated 1,500. It's the maximum claim that you can actually get. That money would be calculated as a percentage of your trademark fees. So let's say trademark designs in European Union. As I mentioned before, the one class starts from €850. So essentially 75 of that price would be refunded to you. So you're getting the trademark only for 25% or a quarter of a price. If you are hiring a consultant to do consultancy work on your intellectual property, you can get refund up to 90%. And then if you're a European Union company or European Union tax resident, you could also apply for trademarks outside of European Union, and for that matter, you will be getting 50%. So let's say you have a company in Europe, you want to go to Canada or United States, you can get half of the trademark fees in those non-EU jurisdictions also refunded as part of this program. So it's really good to stimulate the brand protection of European individuals or companies. Process is as follows. First, you need to apply for a grant. You receive then a letter of approval with your vouchers, and you need to say at the time of application, do you intend to apply only for one trademark or two or three, how many classes? So you actually need to give that information in advance. Once you receive approval, you can then proceed to applying for trademark, and the next day after application, you essentially apply for payment. And normally the payment would come in very fast, in about 30 days. We've seen it before that payments come in quite fast on this program. Now, the only problem there is that this funding is finishing in exactly 1 month from today. So the last deadline is actually December 16. So if you really have been thinking about setting up a trademark in European Union, or you're based in European Union and you've considered doing trademark somewhere else, now is the best time, because you will be getting trademark registered for 50 to 75% off of the original trademark fees. So it's really nice Christmas present before the end of this year. So if it's something you've been wanting to do, act now and apply by December 16. And you can do it yourself, or you can use somebody like ourselves, Cherenko, to help you with your trademark application. So why would you need to hire a trademark expert and not do things yourself? And there is very four common responses to that the trademark expert would typically mistakes and reduce your chances of refusal, and of course increase your chances of success. You need to use a trademark attorney if you are a non-EU resident. That's obvious one, and I've discussed it already. An expert would save you time and reduce risk, and sometimes responding to objections is very difficult. Trademark attorney would know how to respond to objections by the patent offices, and a normal person typically would find it a very difficult task. So next slide just gives you an example that this is very recent. The trademark application was done in July, and just 2 or 3 days ago we received essentially a request to help with the trademark. And I'm not going to read the whole thing, but just going to give you a little bit of communication that a trademark application was submitted, but the applicant has not specified whether it's a principal or subsidiary claim. Again, this is something that not everybody would know of, and the patent office refers to articles in official European legislation, and then they're also further making a statement that the response need to come in a certain format, and the template of this format is given in another article. So again, for an individual who did this application themselves, reading all this and responding in the correct format would be very challenging. Therefore, using a trademark expert obviously something that would decrease the chances of refusal, as I mentioned before, and would avoid any mistakes. So this is just one example where an individual applies themselves. And European Union are very strict. They use legal jargon that sometimes is not clear even to understand. So I'm coming to my last slides of this presentation. As I promised, for those of you who stayed with us until the very end, there will be a couple of bonuses. And there is 5 bonuses in total that I'm gonna explain now. So we offered a free consultation with one of our trademark advisors. So if you would like to receive a consultation, no obligations, no charges, just fill in the form below. If you are ready to proceed to the next stage, we can do essentially a very discounted trademark search. So you will receive a report that will tell you what is the probability of success of your trademark applications, and you would also see all the competitors that have similar trademarks. And instead of charging €90, we are doing this only for 20, just for those attendees who actually came to us today. And in terms of packages, we offer 3 packages that you should consider. Basic package would just cover search and filing trademark at a discounted rate. A standard package would also include responding to basic objections, like one of the objections that I showed you on the screen before. It's considered basic objection. It may not sound basic to a typical individual, but for a trademark attorney, they're simple procedure guidelines and very easy to deal with. And premium package would go beyond basic objections and would cover also significant objections. That means if there is a certain claim or even there is a counterfeit claim by somebody else who wants to stop the application. So the solicitor would be dealing with difficult claims, difficult objections, and handling all that as part of the package without charging any additional hours to the client. So package would basically ensure that there is no additional fees and you just have one flat fee. So use the link below and select in comments which of these packages or bonuses you would like to apply if this is something you're interested in. And the limited time exclusive offer is to actually get the European Union grant and register your European trademark. We understand that some entrepreneurs would find it difficult to apply for trademark and also to apply for the grant. So we made this package, actually two packages together, to help somebody like yourself who either wants to have the trademark with the grant application done within the next 1 month's time. Time is running out, so act really fast if you would like to get this grant and register trademark, whether it's in European Union or you are based in Europe and you're thinking of going to United States. Please fill in this form, let us know what you would like to do, and we can help you also receive the grant in addition to the trademark registration, and we'll be doing it at obviously a very discounted rate, as you can see here on the screen. Now, my presentation is coming to an end. I think we're right on time. We still have 5 minutes for questions and answers. So I will be taking comments from the screen and chat in a moment and see if there is any questions that we could help. Okay, the very first one, I'm showing it on the screen from Valentina. What is the difference between trademark and copyright? There are two separate processes generally. So copyright gives essentially a right to the content as opposed to a brand. So copyright covers essentially any sort of content, could be textual content, could be graphic content or certain websites. And copyright covers the content in its kind of unchanged form. Trademark is related to a specific brand and specific use of that brand, where copyright is not restricted by product type or services or categories. So there's separate processes, and usually trademark would be a standalone, but copyright could include part of the trademark in it as part of the content. I hope I answered it to some way, and copyright would be also more difficult to prove because it's not always possible to register copyright. So I would say similarities. Remember, I showed a slide. What's the difference between TM sign and R sign? So TM sign doesn't mean registration; it's only claiming trademark. Copyright would be similar to TM sign. It's like claiming the right to this content, but not actually having it fully registered. That would be a similarity. Okay. Now going on the next questions could you explain on the specific of trademark copyright with respect to art objects, paintings, or photography? Okay, so normally registering trademark or copyright in respect of that would be slightly different. So art objects, they could be registered as a design. So rather than registering as a trademark, they would be registered as a design. And it's easy to register design of an art product or design of, if it's just illustration of some sort. So it's going to be one of the different types of registration. Registering a name, registering a logo, and then a specific registration of a design that would be more on a copyright side of things rather than trademark. Now I'm not seeing any more questions in chat, so I think we ran out of questions. I see thank you from the audience. I hope you enjoyed the presentation. And I will be just stopping the screen share in a moment and saying again, big thank you for joining us on this time. If you have any questions or trademarks, please use this link and the QR code to contact us, and we'll be able to help you. If you only have 1 month before the European Union grant runs out, so if this is something you really would like to avail of, act now. And if you need any help, just let us know. Otherwise, thank you very much. We'll be seeing you soon on future webinars. Have a good day.